A question I get asked pretty frequently is, do DV defendants have protection orders levied against them? Or in other words, if you're charged with an act of domestic violence, will you have a protection order issued against you? The short answer is yes. The even shorter answer is everyone who's charged with a crime in Colorado has a protection order mandatorily entered against them. The difference is that if there's an act of domestic violence alleged, the protection orders become much more robust, and there's a much higher likelihood that you could get into further trouble and pick up additional criminal charges if you violate that protection order. So let's go back to basics. For any type of charge that anyone is charged with, a misdemeanor or felony in the state of Colorado, a protection order enters. That's always going to happen. The reason people don't think about that as much is because it's a very generic protection order. The protection order will say, don't retaliate against witnesses in the case. Usually, let's say in the case of a DUI or in a drug bust, the witnesses are usually always going to be law enforcement. So in other words, that protection order says, don't retaliate against the cop that arrested you. Makes sense, right? But in a protection order that has a domestic violence allegation, it becomes much more robust. So in a domestic violence case, if there are any allegations of domestic violence at all, the protection order actually prevents you from contacting your victim. And I put it in quotes because a lot of the times domestic cases or domestic violence cases are misunderstood. The typical example that we see with a domestic violence case is, let's say, a husband and wife. If the husband is charged with an act of domestic violence, there is a protection order that automatically enters saying you cannot have contact with your victim, in other words, your wife. And contact means you can't go home if you share the same home, you can't text them, you can't call them, and you can't have third-party contact. And that means you can't have a friend go to check on them to make sure they're okay, because that is you subverting the protection order by having third-party contact. As you can understand, this becomes incredibly sticky and complicated, especially with people who have been together for years. You are in this difficult situation, you're stuck in the jail, you get bonded out, and then you can't even go home or talk to your spouse. The problem is if you do violate that protection order, you can have another charge levied against you, a violation of a protection order charged as another act of domestic violence. It's a brand new case, and now you're even deeper in. So these protection orders are incredibly important to be aware of and know kind of what you're dealing with when you have a domestic violence protection order. But it's important to note that any criminal case has a protection order issued. It's just in domestic violence cases, they're much more beefy and there's more to them. We'll go into more detail later about the differences between criminal protection orders versus civil protection orders. And we'll also dive further into what you can do when you have a criminal protection order for a domestic violence charge if you want to be able to have contact with your spouse, if they're listed as the victim. But for now, just know that in any time there is a domestic violence charge, there will be a protection order that's entered against you, and it's a mandatory issuance. There's no way around it.